In Washington, a divorce generally will take about a year in the sense that the court will issue a case schedule. So when you file for divorce, let's say on August 1st, you'll have a trial the next year on August 1st. And so some families are able to do their divorce quicker than that year. And in Washington, we do have that 90-day waiting period. So no matter what, even if you've got all those details worked out, you will not be able to get divorced until day 91. So if you file a divorce in Washington in court and your intention is to kind of go that litigation route with the hope of maybe settling by mediation towards the end, you're going to go through the discovery process after you file your petition. And that means you're going to do interrogatories, requests for production of documents. You're going to share all the information you need in order to come to resolution on things. The court expects total transparency on your finances. Then we also are going to work out a parenting plan. Sometimes there might be issues with your family where in order to get to a parenting plan, you might need to appoint an expert, a guardian ad litem or a parenting evaluator. If maybe there's some of those concerning things, substance abuse, mental health, domestic violence, then once we get through that whole process, then we usually are ready to go to mediation. And there's a few exceptions about whether or not mediation might be appropriate for you and your family. And then if we are not able to settle in mediation, then you would have a trial. When you're thinking about going to court and getting a divorce in Washington, some of the documents that you really need to kind of have ready are things like your tax returns, your bank statements, your credit card statements, any statements from your 401k. And we look to usually about 3 years of those. And that is going to allow us to share your financial picture so that we can come to an equitable distribution of the property assets and also address the issue of spousal maintenance. Of course, as the divorce progresses, there might be other documents that we need, but those initial documents, actually in King County, they're referred to as the LFLR10 documents, and they just are the basics of what you must share to get your divorce going. In Washington, 90% of cases, probably even a little more than that, end up in mediation. Mediation is mandated for all cases except those that involve domestic violence. And even in some of those cases, you can choose to do mediation if that's right for you and your family. Mediation allows you to come to the table once you and your attorney have done all the work necessary where you know exactly what your assets are, you understand your children's needs, you've created a proposed parenting plan that's addressing those. Mediation allows you to come to the table, and often they're done, you're not in the same room, it's a shuttle mediation where the mediator is going back and forth, and you are able to come to a durable agreement that allows you to resolve your issues without having to go to trial. So you're not having to do all the trial prep and all the financial stuff related to trial. And you have agency around some of those decisions that are being made because you're there with your spouse, your soon-to-be ex, and you are resolving the issue that's best for your family. If you have any questions about these topics, please call us at Elise Bowie Family Law. We would be happy to discuss these with you.